85,000 The Podcast is delivered to you ad-free by our presenting sponsor, AS4.
Do you know that one of the most significant reasons we age is because of something called telomeres? Telomeres are protective, repetitive DNA caps at the end of our chromosomes, similar to plastic tips on shoelaces, that prevent our genetic data from unraveling during cell division. As cells divide, our end caps shorten, acting as a biological clock for aging, and as they shorten, cells age, stop functioning, or die. Introducing AS4, a plant-based, scientifically supported health supplement designed to slow the shortening of our telomeres, the science of aging slower. Powered by astragaloside 4, a bioactive compound derived from the root astragalus, AS4 helps activate telomerase to support cellular health and the slowing of biological aging, proven protection for our chromosomes. Manufactured in the USA in FDA-certified, cGMP-compliant, and NSF-certified factory, quality you can trust. Backed by over 50 years of expertise. And now, special for 85K podcast listeners only, go to as-4.com and use code JUSTICE to get the lowest limited time offer available anywhere on premium health span creating nutrition. That's as-4.com and use code JUSTICE. AS4, live younger, longer.
The interviews and research presented in this episode have been conducted over the course of more than a decade by producer Chris Rare and the team. Every effort has been made to provide accurate, comprehensive, and well-documented accounts of the events discussed. The perspectives shared are drawn from extensive first-hand interviews, archival footage, and meticulous investigation. The thoughts, opinions, and insights shared are those of the individual speakers and not the show's producers or sponsors. The verdict was in. Arthur Andersen was guilty just 5 days after the Department of Justice announced the indictment of Arthur Andersen on charges of obstruction of justice. Nearly 1,000 employees gathered outside Andersen's office, not in anger, but in mourning. Mourning the collapse of a firm they had given their lives to. As cameras rolled and reporters circled, they stood shoulder to shoulder in solidarity, many holding signs that read, "I am Arthur Andersen," and "We are not criminals." Some were angry. Others were simply devastated. But the fight wasn't over. Not yet. With its reputation in ruins and thousands of employees left without a future, Andersen made one final push for redemption. Their battleground, the highest court in the land, the United States Supreme Court. This was their last chance to undo the devastating guilty verdict that had obliterated their reputation and livelihood. Leading the charge for Andersen was Maureen Mahoney, a powerhouse appellate attorney known for her ability to turn the tide in even the most unwinnable cases. Her job? Convince the justices that the government had overreached, that the jury had been misled, and that Arthur Andersen had been convicted under a dangerously vague law. Here's a clip from her opening argument.
Mr. Chief Justice, and may it please the court. The government concedes that the destruction of documents in anticipation of a proceeding was not a crime in the fall of 2001, based upon a statutory rule that Congress had preserved for over a century. The central question in this case is whether Congress nevertheless intended to make a polite request to engage in that lawful conduct, a form of witness tampering punishable by 10 years in prison. We ask this court to reject that interpretation of the statute and to hold that Arthur Andersen did not commit a crime. I'd like to turn first to the term corruptly persuade as it's used in Section 1512 and explain why Arthur Andersen's interpretation represents not only a reasonable reading but a best reading of the language in the statute. The first thing that we see when we look at the statutory context is that Congress did not prohibit all persuasion to destroy documents for the specific purpose of making them unavailable for use in an official proceeding. It did not, because it did not simply say anyone who persuades a witness to do this has violated the statute. It added a very important limitation, and that is the word corruptly. Corruptly persuades. So what kinds of requests are excluded from the definition. When is it that it's okay to persuade someone to destroy a document for use in an official proceeding? And the answer, we think, based on the traditional meaning of the term corruptly, is that corruptly means that you have persuaded someone in a fashion that uses improper means, such as bribery, or you've asked the witness to violate duties imposed by other law, whether that's the duties imposed by contempt or the duties imposed by a whole range of statutes that govern the obligations of people in our society.
Mahoney made a powerful case that the law did not criminalize the destruction of documents before an official proceeding was underway, something Andersen had done under its long-standing retention policy. The other voice you're about to hear is Anthony M. Kennedy, a pivotal figure on the U.S. Supreme Court and one of the 9 justices tasked with deciding whether the firm's conviction would stand or if the justice had gone too far.
Suppose you persuaded, and I know that is not this case, suppose you persuaded the person to destroy the documents in order to conceal a fraud. Would that be corrupt?
If, Your Honor, if it was a crime, then yes. Well, in that case, if the witness knows that you have committed a crime and you are asking them to violate, they have a duty under those circumstances not to assist you in concealing your offense. That's a duty that's imposed by criminal law.
Justice Scalia, Justice O'Connor, and Justice Kennedy pressed the government's attorney, Michael Dreeben, a veteran Supreme Court litigator representing the U.S. government, on the contradictions in the law.
Suppose I have a company and I know that the pattern is I'm going to be audited every 5 years by the IRS. In year 4, 1 year before the investigation, I instruct my bookkeeping staff, keep everything you need to document our expenses, but destroy everything that's remotely related to that or indirectly related to that. Give them just a clean, simple file. Destroy anything, all supporting documentation. Give them what they need and what they're entitled to have, but nothing else. And step up that policy because they're going to be here next year. It seems to me that violates your rule.
Justice Kennedy, it turns on whether the intent there is to subvert, undermine, or impede the proceeding. And the answer is, if it is yes, then it would be prohibited by this statute.
Well, it'd be prohibited to tell somebody to do it.
That's right.
But you could do it. The doing of it is perfectly okay. Doesn't that seem strange to you?
It seems strange to Congress, too. And when this case threw a spotlight on that omission in the statute, Congress didn't react.
I suggest that it throws a spotlight on the fact that your theory is wrong. It doesn't make any sense to make unlawful the asking of somebody to do something which is itself not unlawful, so that the person could do it. But if you ask him to do it, you're guilty, he's not guilty. And that is weird.
What was weird about it, Justice Scalia, is that it allowed...
Hold on. Did we just hear laughter in a Supreme Court ruling? That's not exactly common. But here we are, listening to some of the most powerful legal minds in the country, chuckling at the sheer absurdity of the original guilty verdict against Arthur Andersen. And Justice Kennedy, he sums it up perfectly with 3 simple words. That is weird.
The person to do it himself. And when Congress...
Well, let me ask you about this precise thing. Is it Mr. Duncan? If he had himself shredded the documents or destroyed them, that was perfectly okay at the time it was done.
It wasn't prohibited by this statute. And
it would not have been a violation.
That's right.
But the government got the conviction, got him to plead guilty, apparently, on the basis that if he asked somebody else to do what was perfectly lawful for him to do, it would violate the statute.
That's right, Justice O'Connor.
If it wasn't illegal for David Duncan, Andersen's former partner, to destroy documents himself, then how could it be illegal for him to tell someone else to do so?
But under the statute, with the safe harbor provision in it, is it unlawful for her, as a lawyer, to say, you can destroy these documents?
Yes, it is in this case if her intent was to subvert, undermine, or impede the proceeding.
But your definition of subvert, undermine is if you destroy any document that might raise a question, say in the IRS audit. It seems to me that is a sweeping position which will cause problems for every major corporation or business or small business in this country. I just don't understand it.
I don't think so, Justice Kennedy, because the government's position here has never been that the mere existence of a document destruction policy used under routine circumstances is a violation of the statute. What the government focused on in this case was using a document destruction policy as a pretext and a cover to clean up and purge files when a government investigation was anticipated and it was perceived that these materials would be relevant.
Well, that's like in the old rule in the Army, make 2 copies of everything you throw out. I mean, that's what they're going to have to do.
What seems laughable now was anything but funny at the time. The previous ruling destroyed an entire firm, cost thousands of innocent employees their careers, and it left people like Larry Katzen scrambling to pick up the pieces of a life they had worked tirelessly to build.
This was not a company that was routinely exercising a document destruction policy or a document retention policy to maintain only that which was necessary for its ongoing business.
Yes, it was. The training session that you introduced in evidence was precisely that, a general training session for all employees saying this is our document, quote, retention policy.
As the proceedings unfolded, it became clear that the Supreme Court was skeptical of the government's case. The justices peppered Dreeben with tough questions, challenging the very foundation of Andersen's conviction. And then, in a rare and stunning decision, the court ruled unanimously in Andersen's favor, a 9-0 victory.
The jury instructions here fail to correctly convey these statutory elements. The judgment of the Court of Appeals is therefore reversed. The opinion of the court is unanimous.
The conviction was overturned, but for Arthur Andersen, the win came too late. The firm was already dismantled, its reputation shattered, and its employees were scattered. Larry Katzen.
We had mixed feelings, and I'm probably not much different than if you talk to other Arthur Andersen people. On one hand, we were glad. On the other hand, it's not going to change anything. It's too late. And from that perspective, you felt even worse because here you showed they didn't do anything wrong, but you went through all this stuff.
David Duncan.
It took me a lot to get over that reputationally and get myself kind of back in the saddle. I stayed in Houston, and, obviously Enron is a big part of the dialogue and the community here, so it was very prickly for a long time. Dwelling on it is more not so good memories than good memories, so I just choose to be a positive person and move forward.
Sidney Powell was a federal prosecutor turned defense attorney known for her sharp legal mind and aggressive courtroom tactics. In the Arthur Andersen case, she played a crucial role behind the scenes, closely analyzing the government's approach to prosecution.
The Supreme Court reversed the Andersen decision 9-0 on the indictment and the jury instructions. Justice Rehnquist wrote the opinion for the unanimous Supreme Court and said it was shocking how little culpability the instructions required.
Powell later became a vocal critic of the Justice Department's handling of white-collar cases, arguing that Andersen's indictment was an example of government overreach that destroyed a respected firm and thousands of careers. Her perspective adds another layer to the controversy surrounding the case.
Andersen was the first and last indictment of a corporation because of the debacle it caused and the outrage and the stupidity of the whole prosecution. It could have all been handled civilly.
The Supreme Court's ruling exposed a massive failure in the justice system, one that set a dangerous precedent. If the government could take down Arthur Andersen based on flawed jury instructions, what was stopping them from doing the same to another company? Legal experts called it government overreach. Business leaders called it a tragedy. But for those of the Department of Justice, it was just another case, one that ended in destruction with no real consequences for those who led the charge. In the wake of the Enron scandal and the fall of Arthur Andersen, lawmakers scrambled to ensure that such a corporate catastrophe would never happen again. Their answer, the Sarbanes-Oxley Act of 2002, a sweeping piece of legislation designed to tighten regulations on corporate financial reporting and accountability. At its core, Sarbanes-Oxley was meant to restore public trust in big business by holding executives and auditors to higher standards. It introduced a stricter oversight of accounting firms, harsher penalties for corporate fraud, and required companies to maintain more transparent financial records. The law had been enacted in part because of what happened to Andersen, yet Andersen itself had been wrongly convicted. For former Andersen employees, Sarbanes-Oxley felt like a cruel twist of fate. The firm that had been made the scapegoat for Enron's misdeeds was destroyed, while the actual perpetrators of the fraud, executives at Enron, were the ones whose actions made the law necessary in the first place. So while Sarbanes-Oxley reshaped corporate governance and changed the way businesses operate to this day, for those who lived through the downfall of Arthur Andersen, it remains a bitter reminder of justice delayed, and for many, justice denied.
What would you say was the lowest day of your entire journey at Arthur Andersen?
Lowest day at Arthur Andersen. That's pretty easy. First day when I got fired. I mean, I went there in the morning to talk about all the good work we're doing, and he wants to expand and give us more work. And that afternoon, I get fired and said, we don't want to see you anymore, and you're out of here. I mean, that was the start of something that I knew nothing about. Just hours before. It just kept getting worse and worse and worse for the next 6 months. One of the people that I used to do work with, he was a psychiatrist to help companies evaluate people. I talked to him when the thing was going on. He said, I think you need to go see a doctor. So I made an appointment and I explained what was going on because at that time it was confidential and I don't want to share information that I'm not supposed to. But as I was talking, I started crying like a baby. And he then calmed me down and told me that I should leave and quit, that it's not good for me. And I said, I can't do that. And I didn't. I went on and he gave me some medicine to take, which I still take to this day. In February of 2002, that was the day I was going to retire. February 19th was my birthday. My kids came in from college. It was not a happy thing, and I never had my retirement party.
When this is done, we need to do a party. Yeah, we need to do a party with the family. We need to exercise that demon for sure.
Well, hopefully we'll have a great movie come out of this thing and be shown throughout the world and have a party on opening night of that party. That would be good, because I just want Arthur Andersen to be known for what it really was and to show the power of our government, how deceitful they were and how wrong they were, and that this should never happen to anybody ever again.
Throughout this series, we've pulled back the curtain on Arthur Andersen, a firm wrongfully accused and its legacy shattered. But if they weren't the ones to blame, then who would be? In the next episode, we turn our focus to Enron itself and more. What was really happening behind the scenes? How did a company once hailed as the most innovative in America implode so spectacularly? And why did Arthur Andersen take the fall? The truth is more twisted than you think. That's next time on 85,000. Everything you thought about Enron and Arthur Andersen is wrong.
And don't forget, this episode of 85K the podcast was presented ad-free to you by our presenting sponsor, AS4. And now, for a limited time for 85K listeners only, go to as-4.com and use code JUSTICE to get a bundle offer on AS4 and free NAD Plus from 24K Wellness. Yes, free. The perfect cellular health span complement with your AS4 subscription. Greatly improve your health span and support the 85K podcast all at the same time. This combo offer is only available for a limited time to 85K listeners, so grab your health by the horns and go to as-4.com and use code JUSTICE. That's JUSTICE to get your free NAD Plus with AS4 subscription. The ultimate cellular combo. NAD Plus and AS4. Live younger, longer.